Ladies and gentlemen, welcome. Welcome to this lecture about Chapter 10. And Chapter 10 has as its topic regulatory services. Now, first of all, the notion that when you are a manager, you will be cooperating with other parties, colleagues within the company, but also external services providers. You may think of an advertising agency, a web developer, a market research company, a logistics company, a cleaning company, whatever, you as a manager will have to deal with them. And that dealing with them, of course, involves managing them, making sure that they realize what you are responsible for and do that within the budget which is assigned to you. That basically is the essence of management. And the focus of management will today be on chapters 10, of which the topic is regulatory services providers. Now, what we do is we take as a starting point this already often used division between external and internal. This can also be applied to regulatory services because you will have in the company in which you work probably a legal department or whatever it is called, a compliance department or whatever it is called, or maybe legal and compliance are combined. And outside you have external services providers, of which the law firm is of course the most easy to understand example, but there are more and there are others, and as said, your task is to manage them. Now, this division between internal services providers and external services providers represents a choice. And that choice is what in business terminology is called make or buy. In other words, when you make, you have legal support in-house. You have lawyers which are employed by the company which also employs you as a manager. You, the legal department, may decide to buy, and buying means you go outside of your company to find services providers to do tasks which you cannot or want not do internally. That is the essence of what we call outsourcing, generally applied in the context of manufacturing and logistics, but of course we can also apply this concept at the level of outsourcing legal and of course also compliance. Well, for all those reasons, managers, especially business managers, have a peculiar idea about the legal department. It is generally seen as not very productive for the business. It is seen as a department where if you go to with good ideas, you are criticized for it, and often the message you get from the legal department is that the good idea which managers have is not possible. So there are all kinds of names for the legal department: the no department, the vinegar pisses department, the murder of brands department, all kinds of negative connotations which simply result from the fact that lawyers have a specific task to accomplish, and if they do that rather rigidly, that does not really contribute to the business. The same is of course true if managers approach legal too aggressive. It is also not productive. But the message from this course and from this chapter is cooperation is unavoidable and is absolutely necessary in these difficult times and days, for the simple reason that all functions, including legal, should be involved in what the business is about, and that is essentially about creating value. Now, apart from the image lawyers have within companies, also in the outside world, it is also not always that positive. It is even so, and you can see it here, that in the US, but that's a very legalized society, so we should take that into account, that lawyers are among the most despised professions. And you can see it in the title, Why Does Everyone Hate Lawyers So Much? Give us a break. And there's a fantastic quote of William Shakespeare below it. It's no longer copyright protected, but what William Shakespeare once wrote was the following: the first thing we do, let's kill all the lawyers. Now, I don't want to say that that is something which should be done. On the contrary, but it illustrates the problematic position of lawyers in society and within companies. Within companies, the legal department can have various names. There is no prescribed nomenclature, terminology for the sign which indicates where the legal function in the company is. So you'll find, and you see it in this table, all kinds of designations. When you are trained for business as a business manager, you should be able to recognize this, and by recognizing it understand what is behind it. Whereby, of course, the most important distinction to be aware of is the distinction between legal and compliance. That distinction is becoming increasingly important. So, when you see signs of departments, try to think for yourself, is this a department which is involved in legal or in compliance or in both? And what would it mean for me as a business manager? Now, externally, we said in the beginning, you use other people, other services providers. We mentioned the advertising agency as an example. Regulatory services providers you'll also find in all kinds of specialisms. And those specialisms are, I suppose, recognized by you when you have taken a law course. When we talk about the traditional external law firms, then generally there are two types of services these provide. That is, on the one hand, legal advice, and on the other hand, representation in court. We see advice on the left-hand side, followed by litigation. The terminology used for lawyers differs. In common law countries you will find solicitor and barrister. The split between advice and litigation is not perfect, but for the bigger part it is. Barristers help in courts, solicitors advise, and in the US and other American-oriented countries you'll find the word attorney used, and attorney in the sense of a lawyer as we know it, a lawyer who works for a law firm, will generally combine litigation and advice. Some companies, some countries I should say, have notaries. What notaries do differs among countries. It can range from rather simple real estate processing, which is for the bigger part the work of a notary in Spain, to that, plus incorporating legal entities, which is what the notary does in, for example, the Netherlands. So also beware that a notary is not by definition what a notary is in your country. Now, intellectual property, as we have seen, is incredibly important for business, and you know we have different IP rights, and that is reflected in the legal services providers of intellectual property knowledge, patent agents, trademark lawyers, design lawyers, and copyright lawyers. For you, the challenge to find the right one who can best serve your business. The same with an advertising agency. Where is the agency which can best serve your purposes? Tax is, of course, also an area of advice, which is not only done by lawyers, but also by non-lawyers who are tax consultants, and most accountants also help you with tax issues, although of course tax consultant and tax accountants do not have in general, the right to litigate, to represent a company in court. Now, then we find all kinds of other related services providers like bailiffs, who in the Netherlands issue writs of summons, who can do seizures and are involved in public sales. Many a bailiff office also collect debts, debt collection, convincing, pressuring non-paying debtors to pay for an invoice. Some law firms are involved in interest representation, and also in the context of intellectual property, you may require the service of a market research agency, for example, to do a research on the question whether a color or a product is recognized among a majority of the public. That could help you in ascertaining an IP right on, for example, a color or any other IP issue. But market research companies you'll find in the context of both competition law and in the context of market research. Now, we mentioned the word legal department. You got an overview of all kinds of designations used in practice. And we're now going to dive a bit deeper into the legal department with a focus on the legal function in the context of a company which operates on the EMEA market. Now, this company, any multinational company, will have a structure. Now, this lecture will not deal with potential organizational structures, as for example outlined in literature by Mintzberg. But there is, of course, a famous business saying which says structure follows strategy. Now, the strategy of a company, what it is actually planning to do in its markets with the products it has chosen to market, that is the starting point for completing the organizational structure. Now, apart from that, many an international company, and we see here a description of how Starbucks is organized, many multinational companies splits up the world in parts and assigns to a certain degree authorities and more or less a unit structure to this geographical structures. Now, it's a bit hesitant when I speak about it because I don't want to go too much in the details, because this is not about organizational studies. It is about law, and specifically about how the legal department could be organized within the setting of a multinational company also operating on EMEA. We approach it rather simple. We said you have legal, you have compliance, and we know that within business studies the distinction is made between centralizing and decentralizing. Now, the decentralizing can be regional or can be at the level of a subsidiary in a country. But with these four elements, we can build a matrix and very simply identify the organizational options with respect to legal and compliance for a multinational company. Basically, you can centralize everything, legal and compliance. You can also centralize legal and decentralize compliance, or you can completely decentralize both, but generally in practice we will find a mixture of some areas of law centralized, other areas of law decentralized, compliance usually worldwide oversight, with to a large extent decentralization, because compliance is for a big part about meeting the national rules of a country. So from that perspective, decentralizing compliance is often a logical choice. Now here we have a generic structure, just to illustrate to you how in practice it can work out. We start here at the board level, and the board will also, of course, use external counsels. Boards have big responsibilities. Boards are responsible for corporate governance. Boards will have to take major decisions with respect to the business they run. So not only will they involve internal lawyers, but frequently they will consult external law firms. The company itself may have a global legal and compliance function, but also at the level of this function, from time to time, external advice will be sought with external counsels. Then you may encounter something specific in multinational companies, and that is if the company has a lot of value represented by intellectual property right, then the multinational company can choose to protect those intellectual property rights from seizure by creditors by transferring all the IP rights into a separate entity. For example, a Swiss entity is created by an American company, and all the intellectual property rights created anywhere in the world are transferred to the Swiss entity. So they are more or less out of the company, and they are free from potential seizure in case of problems or in case of bankruptcies of part of the company. Now, the global company can organize itself into regional divisions, regional units, and we just take one, the EMEA, because that's what we focus on. Now, in the EMEA, there may be a function centralized somewhere in Paris or in Amsterdam, where the regional legal and compliance function is, who of course also will consult from time to time external counsels. And then we have the subsidiaries which report probably to the regional, local and compliance. And these subsidiaries will, when they are fairly big, have their own legal department, have their own compliance department. And when they are smaller, they might not have a legal department, but they probably have someone who full-time or part-time takes care of compliance issues, with of course the opportunity, if needed and possible within their budget, to hire external services providers. So this is a picture of how, rather generically, we can learn how the legal and compliance function are placed in the organizational structure of a multinational company. Now, on this slide, you see on the left-hand side a little quote from an article. The article uses the words, quotes the words of the lawyer, the in-house counsel of 3M, a big multinational company. They have a legal department, and this legal department, which is referred to here as the in-house legal function, this legal department is increasingly confronted with new areas of risk. And we see here at the bottom cybersecurity, we see risk management, we see compliance emphasized as an increasingly complicated area to manage, privacy issues, the changing and challenging human resource issues. Think about the changes in employment law which take place in all kinds of countries, including the Netherlands. And these are the typical issues which corporate counsels, as it is called here, general counsels, legal managers, have to deal with. This is not only a challenge for legal departments, but this is only a challenge for you, if I may address you as a manager. If we look at the management challenges and we look at what the annual CEO survey report of Price PricewaterhouseCoopers says, then we see a list of the top 15 threats, and for 2020, and I just want to point out the first place, and that is over-regulation. This is basically the same problem which this General Counsel of 3M gives us: an increasing amount of rules, an increasing complexity of topics, new topics which are also regulated. The company has the challenge to identify what changes. If not, they cannot adapt their business to it. Now, this is already quite a challenge for legal people, managers, but consider it also from the perspective of the average manager who is not trained in law, and you understand why managers indicate that their biggest problem in running the business is over-regulation. Now, this is nicely reflected in the words of this CEO, and his quote comes from this KPMG report, which indicates that as a company you have to be very flexible nowadays. If not, you become irrelevant. And what the CEO is stating reflects what we just saw on the previous slide. He says, a key focus for me is the evolving regulatory and policy landscape. It's a really difficult thing to get your arms around because at the end of the day it changes. So regulation, law, compliance are moving targets of which it is increasingly difficult to identify what changes. So that needs to be managed. Can you as a manager simply say legal has to do it? No, because identifying changes in the environment is typically a business task. So the best approach is managers who are aware of what needs to be identified, and lawyers who have an idea about where the developments will happen. If they can find each other in a proper briefing and agreement, it can work. Otherwise, they work separately and they will not come together in such a way that the company benefits from it. Now, compliance was mentioned, and compliance also poses, it's a fairly new area, but it's becoming increasingly important, imposes typical challenges. Here you find an overview. It comes from an article, and the article gives challenges which are now, challenges which are coming in the future, and challenges which are a bit further away for which we have to prepare now already. So what you see is an evolving area of topics. It starts in the present with the challenge we just discussed, identifying, plus all kinds of new areas popping up. Those new areas need to be managed in the near future. And over 10 years, we see a compliance function which has developed into a function which uses IT, artificial intelligence, machine learning, etc. to make sure that the company in this future of over 10 years is still able to be compliant. Because the viewpoint and the message from this is compliance will be confronted with an enormous amount of developments in the near future and in the further future. Strategic thinking means that you as a manager start thinking now about what you gradually have to do to be ready in X years. What you have to take into account in starting that process is reflected in this overview of compliance challenges. Now, in the context of this course, which links business and law, we have also, be it briefly, touched upon the topic of market entry strategies. Now, market entry strategy sounds simple. It sounds like, let me choose the market which is most suited for me, and generally the idea is those are the markets where I can make a lot of revenues and which are not too complicated. But this not too complicated issue is not that easily assessed, but that non-complicated issue is actually dealt with in some reports. And here we have an overview from one of these reports, and this report gives you freely, it doesn't cost anything, an idea about which countries are extremely complicated, where your initial conclusion should be, don't go, or if I go because I see interesting prospects for profit, make sure that I'm able to have a compliance function which is so professional that it can be handled by my company. But if you want to minimize your risk, you better enter a country which is not too complicated, and then Mauritius and Cayman Islands will probably not have that much revenue potential. But if you look at the Netherlands, Denmark and the United States, you have a couple of markets which, I can speak simple from here, probably have potential and are among the least complex. That's an attractive prospect, I would say, while the others, which are very complicated, should only be entered when you are completely sure that your company is able to manage it. And that is meaning, in this context, that you have a legal department which is staffed in such a way that it has the competencies to deal with it. It's okay if you go to China, number 6 of the most complex jurisdictions, but do you have in your company a lawyer who understands Chinese and who is a specialist in Chinese law, or are you able to find a law firm which can be available to you to guide you in this process? Those are strategic questions which also, of course, involve cost, but that is what makes business interesting. So we talked about this company considering to enter China, and we talked about a choice to employ a Chinese lawyer, let's at least say a lawyer who is knowledgeable about Chinese law and China, or find a law firm which can support you. So it's basically a choice between doing it in-house or outsourcing it. That is what in business is called a make or buy decision. Now, make or buy decisions looked at from the perspective of make or buying legal services is, of course, like any decision, a decision which requires criteria. And here, beautifully formulated with 5 C's, you'll find criteria which you can take into account when you are facing this decision. Shall we hire a lawyer, or shall we find a lawyer outside and hire him for a specific time or project? Criteria are cost. At a certain point in time, it can be cheaper to hire lawyers instead of giving the work to outside lawyers. Outside lawyers generally have much higher fees. The complexity can play a role. We know that, for example, competition law is fairly complicated. Generally, in-house departments lack sufficient knowledge for dealing with this specialized area. So if you are, as a company, confronted with that, you simply have to go outside. It can be that your legal department is understaffed, that you simply do not have the capacity to do the work, so that may force you to go outside. Then you should always realize that external law firms, especially if we talk about the big names, they have generally a positive reputation. And it may simply be so that you as a legal department are fully convinced that your choice is defendable towards, for example, a supervisory authority, but suppose you would put the question at the desk of an external law firm with a long, impressive name, and they would put in writing that your decision is correct and indicate the reasons why they support your decision. Then you have a piece of paper which you file, and in the case a supervisory authority would inspect you or try to fine you, you can draw the paper from the desk and say to them, look, you may be right, we may be wrong, but look at all the effort we made to make sure that what we were planning to do was acceptable. We evaluated it, we hired an external law firm. This will probably lead to the supervisory authority giving you a lower fine. So in that sense, it could be a cost-saving approach. And then finally, of course, but this differs per country, going to court may only be possible with the help of a lawyer. Representation might be mandatory. In principle, it is also mandatory in the Netherlands, but for small cases between 25,000 euro and for labor disputes, mandatory representation is not the case. You could theoretically do it all by yourself. Whether that is a wise choice, well, in generally, certainly in a business setting, I would say it's debatable. If you're sure that your legal department can handle it, do it. If you're a private person, it is generally not advisable to do it on your own, but you better spend the money on a good lawyer because he can represent you in a professional manner. In other words, more chance of success in a court. Now here we have another interesting quote by the GM legal counsel, Mr. Liotta, and he perfectly verbalizes what the situation in a multinational company is. First of all, multinational companies are dealing with complex issues. Those complex issues are generally not possible to be taken care of by the average law firm. So these multinational companies generally resort to the big international law firms. But this comes at a price, and lawyers in law firms have a specific way of operating. The friction, the differences between lawyers and managers, you will also find at the level of in-house lawyers and law firms. The general criticism of in-house lawyers is that external law firms are incredibly expensive, that they may lack the business knowledge which the firm expects a lawyer to have, and that they don't communicate and report in business terms. So the general criticism is a law firm can make a big report, but I only want some bullet points which tell me whether I can do it or not. Now, it is unavoidable for an international company to cooperate with law firms. The philosophy of 3M is, if not absolutely necessary, don't do it because it costs money. But if you do it, there is a network available of firms we have chosen to cooperate with because they have demonstrated that they can serve us properly. And if needed, we can contact them. That's the situation, the approach which is so nicely phrased here. The approach of 3M, the approach I think is rather representative for the general idea of this cooperation between in-house and external legal services providers. Now, legal costs can represent a substantial percentage of a company's revenues. That is, of course, affecting profit in a negative way. In the previous financial crisis and in the present COVID crisis also, companies are considering to lower legal cost. What has happened is that companies started looking at procurement and try to see whether the procurement knowledge which was developed could be used to lower legal cost. And that has led to some strategies which you see depicted here, 4 categories with details below them of procurement strategies applied on legal. Now, if we run through them, we have pay less, use less, not useless, alternatives, and eliminate cost. Now, pay less can be realized by requesting proposals and then of course discussing them to get them lower for projects or specific services. You can ask more than one law firm to tender, to make a proposal, and you can also try to change the fee structure by getting discounts or by agreeing not on hourly billing but on a lump sum, a fixed fee for a project. External, now I go to the use less. External is more expensive, so if you do more in-house you save cost. Assess necessity means don't go outside unless absolutely necessary. Make processes, for example internal processes or cooperation processes with law firms, more standardized or automate them, and in that way try to have the work done faster, and because it is faster you either save time or you save hours of the law firm. Now, we discussed outsourcing and offshoring. Offshoring means that you completely place the legal function somewhere in the world, like in India, and then in India you have a legal department which, if you are a multinational, serves from India the whole world, all subsidiaries, with legal support. You can indicate which law firms you want to work with on a preferred basis. That can entitle you to reduce cost. And some companies have recreated a law firm by a panel of law firms. So they choose a law firm for IP, they choose a law firm for contracts, they choose a law firm for international contracts, and all these law firms cooperate in a panel, and that panel exclusively serves the company on the topic they have been selected for. That means on the one hand that you improve services, and on the other hand that you reduce the number of firms you cooperate with, and that you reduce the overall costs of legal support. Now, you can eliminate cost by avoiding having to go legal. You know that in contracts, business-to-business contracts, the preferred dispute resolution methods are amicable solution, talk it out, followed by arbitration, and you can of course also reduce cost if the non-legal staff in the company is better aware of what the rules are and how they should comply with it. You can also use the staff to complete templates as much as possible, and in that way reduce the work of the legal department. So you see there are various options with which you could be able to save on the cost of legal or to improve the effectiveness of legal. Of this panel approach to save costs, I just want to give you an example. We have here Unilever, well-known multinational company, and they have created in 2018 a global panel, and this global panel consists of 8 firms, and all these 8 firms in a specific area are preferred suppliers, so can be consulted from within the organization with respect to questions in the areas they have committed themselves to. We're reaching integration. We're going to look back and we're going to look forward, and we're going to discuss a rather simple model which is based on the steps in strategic management in a business, and we're going to apply those principles on the legal function. We're going to look at strategic management of legal from the perspective of three levels: strategy, operational, and cost level. What you see here now is the strategic level planning, and we should simply realize that before any objectives or strategies are set for legal, which would be a typical strategic management approach, that we first have to look at what the objective and strategies at corporate level are, because they provide the basis for deriving objectives and strategies for the legal function. Here you find some examples of what typical corporate objectives and strategies could be, and that is translated into objectives for legal, of course specifically from the perspective of how can we bring them closer to the business, how can we reduce legal cost. To develop objectives in business, conceptual frameworks are used. We have the Boston Consultancy Group, we have the SWOT, we have the Taos analysis, go on. So it would be handy if we would have a conceptual framework and an ID matrix, which could be helpful for deriving typical objectives which we can use for the legal function. Here we have one which is based on the vertical line on tasks which you could ask legal to do, like developing new templates, like negotiating better contracts with the law firm, like reviewing patents, like approving advertising material, like managing the competencies of the legal department, like analyzing what regulations are appearing with respect to platforms, cybersecurity. And then you combine that with the 5 C's, which you see on the horizontal line, and then you apply the principle which is so often applied in business models. You think about developing and contribution. You think about developing and cost. You think about negotiating and compliance. You think about reviewing and corporate governance. So by creating a focus which results from combining 2 elements, you hope to arrive at ideas which you can translate into objectives for legal. We leave it a bit open by including a new section. You might have completely new ideas about what legal could do for the business, or what legal could do in your typical business, and that can be linked to developing, negotiating, etc. on the vertical line as well, and hopefully that also translates into, conceptualizes ideas for objectives for the legal department. Now here you see it applied to IP. On the horizontal line you see different types of intellectual property rights, and if you want to manage legal with respect to the intellectual property rights of a company, you could apply this, and you could also use the same approach, develop and patents. Does it result in a conclusion on something I want legal to do? So with all the vertical elements and all the horizontal elements, you make combinations in the hope that this focus stimulates your creativity to come up with real objectives for legal. At the operational level, we can do the same, but here we look at contribution, cost, compliance, corporate governance and competencies as well. And here, of course, the question is, what do you actually want legal to do? How do you translate the objectives which you conceptualized on the previous 2 slides into actions legal must implement, into things they must do? And in the textbook you will find an example in section 10.4.2. All this translates into cost. And when we talk about legal cost, again, we go back to the very beginning, internal and external. We have internal cost of the department and we have external cost of the law firms. That results in a total cost, and those total costs can be expressed as a percentage of total revenues. Now, this can of course also be used to create a cost target. You can assign to legal the obligation to reduce the total percentage spent on legal cost expressed as a percentage of the revenues. Now this is again the formula which you can use, a rather simple formula I would say. And of course we did not take into account cost accounting practices, how you calculate cost, but that is finance, that is accounting, which I leave to the specialists who study that. Now I hope you got interested in what we discussed, and that is management of the legal function. I realize that the framework we just discussed is in itself rather simple. But okay, I think it's useful to get a grip on what legal is doing. But I would like to refer you to two additional sources which can help you in developing more detailed ideas about managing the legal function. The first is an overview which comes from an infographic which is produced by legalexecutive.com and which tries to illustrate to you what the past, the present and the future of the legal department are. Generally it comes down to developments we discussed in this presentation. Cost will have to go down, IT elements will be introduced in the legal function, and ultimately it must lead to a more professional legal department which is able to produce at least the same at lower cost, or preferably more at lower cost. And finally, if you have become really interested, I would like to refer you to this report by PricewaterhouseCoopers, which is a rather extensive report on how you can introduce metrics to get a grip on the legal department. Now, the report is extensive, so we will not fully discuss it, but I'd just like to show you one example. One of the elements discussed in the report is strategy, and the whole report is based on the idea that if you measure, you can improve, you can steer. So the metrics which the report proposes at the level of strategy is calculate the percent of the work of the legal department which is strategically aligned. That sounds simple, but they do give us parameters, how you can measure it. And for a lot of areas of the business, they give you this type of overview. It is not simple, I think, to introduce, but it is useful, so I would really advise you to have a look at this report. And finally, we should realize ourselves what we have been doing, and that is that we have been trying to bring business and legal, and nowadays we should also say compliance, closer to each other. The underlying idea is that if they get closer, if they cooperate better, they will be able to create more value for the company. So the challenge, the future challenge for managers and lawyers is to dance together in a tango, and you know it takes two to tango. And the final words of this lecture are what is reflected in this picture. It takes two to create value. Thanks a lot. Bye bye.